Give me 1 second, just getting all this stuff up. Mr. Gagnen and you're Mr. Amrine.
Yes.
All right.
Correct.
Oh, did you give me that document? And I didn't.
Yeah, I put it on top of your calendar. You
Did
need
you?
mine?
Well, I didn't find my calendar yet, so I will. Oh, it's right here. I
Got it? Okay.
Okay. We will go on the record in the matter 25 SC 202, Joseph Gagnen versus Charles Amrine. Appearances are we do have both parties appearing in person without counsel. We are set here for the second part of this court trial. We had a lot of exhibits and a lot of discussion. I have all of the documents from the previous matter in front of me. Mr. Gagnen, you were in the process of discussing or testifying about the damage and the container and where you were going with that. Before we begin and you continue, both parties please stand, raise your right hand and be sworn in.
Do you affirm that the testimony you're about to provide in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes, that's I do.
All right, you may be seated. Okay, Mr. Gagnon, you may begin.
All right, Your Honor, and we were, I would just begun when we needed to stop last time interviewing Mr. Amrine's as the first person I had called to ask some questions.
That's right. Okay, and then were you going to continue to have him testify, or
Yes.
where were you going?
Yes.
Okay, and so I'm just going to allow you to continue to sit there instead of coming up here, and vice versa with when you give testimony or question people. So you may continue. You go ahead.
Okay, and with the court's permission and Mr. Amrine's, Chuck, sorry, do I have your permission to call you Chuck?
Sure.
Because I butcher your last name every time I say it. All right,
Right.
Thank you, Chuck. All right, so I'll start with the kind of resuming the questions I was asking before, and I apologize if there's a little bit of overlap, but set some context. When we were here last time, you had indicated you'd been in the container business. You had 17 containers that you rent out. I wanted to ask you, how long have you been doing this?
4 or 5 years.
And in that time, how many rent cycles would you say you've had?
20 to 30.
Okay. And would you consider yourself, an expert or highly experienced in the field of containers, container rental?
Just moderately. I would judge myself.
Got it.
I'm sorry, can you say?
Oh, I'm sorry. Just moderately as far as experience.
And have you had any experience or scenarios in your rental history where your clients had issues with intrusion of rodents?
Never.
Okay. And I'd like to ask if I can include an email. Chuck, I want to give you a copy. Your Honor, I'd like to give you a copy to reference the next set.
Of what?
It's an email
From what?
from Chuck to me.
Okay,
Is that okay?
that's fine. It needs to be marked as an exhibit if it already has not been
What
marked.
is the date on that email?
On 9/18.
You introduced that as document 24 or as exhibit 24 on the last court date.
Okay. My challenge is, is that where it referenced the 9/16 email in the title?
I have email of 9/18.
Yeah. This says 9/18 on the top, and it has It's just 9/18.
So you have a 9/16, a September 16 date too, in addition to the September 18th date?
Give me a minute, get in there. I have the list of exhibits that I got from the court.
Look at the top of that email. Just tell me the date that's on that email.
Yeah, it's 9/18.
Okay, then we're all good. We already have it. It's exhibit, document number 34, exhibit 24.
Okay, and Chuck, do you have a copy of that?
He probably does not. If you're going to redo it, just go ahead and, if you have copies, just give him an extra one. I have it in front of me right now.
Okay. Chuck, what you see in front of you is the email you sent to me on 9/18. And I've put a line across the top half versus the bottom half. I'm referring to the top half. A moment ago, you indicated that you did not have any experience with rodent intrusion in your rentals. I wanted to ask you to, read the first half of that email. And then I have a question.
From the top to the line.
Yes, please.
Okay. Joe, thanks for the note and info. I'll use this in the future for my customers. I did a little talking with my suppliers and others as to how to handle the situation. Number one, everyone was incredulous. Number two, one of my wholesalers who has been in the business for over 15 years and does about 100 times the volume that I do, said he has never had a mouse situation.
Okay, you can stop. I can read. I know how to read that too. So just have him pick out the important parts that you want, because it's a long email.
Okay, and so the key point here is, so you cited literally, thousands of cases with no issues with mice or rodent intrusion. In your own experience, you didn't have any, and based on your sources, you've got, 1,000 examples where that is just not the case.
Correct.
Basically inferring that, the storage containers, are not subject to intrusion by mice.
I don't think that's what he said. That's not what it said. I don't believe he said they're not subject to intrusion by mice. He just said he, in his career, has not had any history of mouse activity. So you're twisting the words.
Okay.
So you can ask what exactly he said and have him say what he.
So I'll ask the question, Chuck. So, in your experience, in the experience of your suppliers, what's unique about our situation, my situation? And Chuck, that's let me phrase it another way. We both sit here today having gone through the experience, and we know where we're at and where we are today. Based on your experience, your supplier's experience, your colleagues and the numerous examples, and what we've seen in terms of evidence and pictures and.
Is there anything different from his experience versus any other customer experience you've had?
Yes, this is the first and only time that I've experienced, or my suppliers have experienced the mouse intrusion.
That you're aware of?
That I'm aware of.
Done. Next question.
And what is unique about our situation or the container that I rented that drove that outcome?
There was, the mouse got in. You've documented that there was a hole in the gasket where the mice supposedly got in. And you've documented that thoroughly.
Okay. And do you agree that that's the likely point of entry and exit?
I agree that that's the likely point of entry and exit.
I guess that's all that matters.
Okay, I agree too.
Okay, thank you. I'll move on. Chuck, I've presented a lot of pictures showing that point of entry and exit. Would you say the gaps that we've looked at in those pictures is typical of a container and the doors and the door seals?
The gap, the hole in the gasket you're asking,
Yes,
is that typical?
yes.
No.
Okay. And if the doors did not have that gap, do you think that it's likely we would have had the issue with the mice entering and exiting the container?
I think just from the evidence of hundreds and thousands of other situations that I know of, I think the answer would be no.
Okay, thank you. All right, now I want to speak to, and this is an extension of the questions we were literally on when we paused last time. And it's really about the process you went through to prepare the container to bring it to me. And can you tell us a little bit more again about, what's the inspection process you go through to prepare a container for rental?
Yes, when I buy them, I look at those gaskets. If that's the focus of what we're talking about, I look at them very clearly before I even buy them from my supplier. In this particular one, not all these units that I have, but this one, where you photograph, is painted, and I pressure wash them with extremely high temperature water. And then I painted the outside flat brown, and I painted, as you can see, the inside glossy white. This is extremely rare in the industry. Nobody paints these things. They're old containers. These are all used. I don't know of anybody else that does this unless they do custom work on them. So that's the difference that you have from the 99.9% of the containers that I'm aware of. And during that inspection, or during that washing and painting, it precludes or includes an inspection. I'm looking at everything, top, outside, inside. And if you do, when you pressure wash them, obviously if there's a leak or a hole or anything like that, you're going to see that on the inside when you walk there.
Okay, and
here I'm gonna kind of direct you, so you know the focus of this case here. I get it. You had rodent damage in your container, but the focus of the case here is the contract. You had a contract signed with this individual. So that's your focus. The focus is the contract. And if there's anything that would kick it out of the contract, okay? And like negligence or, any, like he was reckless or he intentionally did anything, that's the focus of this case.
for sure, and
sure.
yes, and I'm sorry, I didn't mean to say that in a flip way at all, right?
Oh, you did not say anything in flip. I was doing it. He was going to raise his hand to say something. So that's why I was like, no, because this is your time.
Okay, and so it is my assertion and has been that Chuck was negligent. Chuck was in not properly inspecting the door seals and not properly maintaining them.
Okay, based upon the contract, that's what you have to look at. I understand your argument and I understand what you're saying, but it has to be focused on the contract and how he violated that contract.
Understand?
Okay.
And in the contract, it doesn't say anything specifically about the door seals or the maintenance that I'm aware of. And so what I'm trying to establish is what process Chuck went through, what he observed, what the maintenance cycle was for the door gaskets. And so that was going to be my line of questioning. And I guess, Your Honor, I'm hearing you say that's not relevant. Is that I'm sorry, I shouldn't say, you're not saying that.
No, without wasting more of both of your time.
Fair, I'm all for, so.
This is a more simple case than
I'm making it out to be.
I'm
don't pull a punch, please. Tell me what you think.
not, because this is a contract, and with a contract, the court must read the contract, the words in the contract as the plain language they are in that contract to see what is binding
Yes.
between the parties. okay?
Yes,
And there are only certain situations that you can break the contract or go outside of those four corners of that page. And so what your job is to prove that he violated that contract.
fair point. And I went there last time with a set of questions around the legal terms in the contract specific to water resistant and you asked me to leave that.
Well, because here's the thing. Again, to be blunt,
Yes,
the definitions of whatever you believe they are should have been in the contract. Because it has to go on plain language. I'm going to tell you, in a case like this, a simple case, if this were, I had two attorneys and two people here and they're fighting over this, they would just say, Judge, here's the contract, read the contract, tell me what it means. Tell me who's at fault, what is binding and what is not, and all of those things. I can easily do that right now. I'm letting you try to prove your case.
got it. So I'll ask a few more questions and I'll move on and try to figure out, where we need to go that would be helpful to all parties here. Chuck, last time we met, I had asked you a set of questions about the inspection you'd done. Did you go inside the container? Did you not? You indicated you had not. I'll say this, since you've got the container back and are able to look at it and observe exactly firsthand what I experienced. Also, you came in late July and August and did the same thing. Have you, subsequent to renting the container to me, have you done maintenance on those seals?
On that particular unit,
Yes.
I got 5 of them in my backyard. I'm working on them, but I haven't completed this one.
Okay. Part of our contract was the written verbally back in September. Did you not tell me that you inspect the containers and that they are, ready for rental, that you took me through the similar verbiage that you did today and told me that you check the doors for that they seal, you check for holes in the unit. You took me through the process describing the integrity of the container. And we also had a conversation relative to my alternative, wanting to use the container versus throwing my household goods in a pole barn. Do you recall that? I'm realizing, do you recall that conversation?
No.
Do you recall telling me about what you do to prepare and inspect the containers?
Did he make any promises, and were those promises in writing in the contract? Because that's why we're here, is a contract. Whatever is said in the contract.
So,
whatever is said outside of the contract doesn't matter. And in Wisconsin, subsequent remedial measures, let's say that something happened, you're like, oh, Mr. Amrine, like, this is what happened, da, 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 da. And he goes, well, Mr. Gagnen, thanks for letting me know so I can address this, so I can make sure that this doesn't happen, to somebody else, because this is kind of not cool, okay? In Wisconsin, the fact that he may have then fixed that container and, welded that hole shut or did all the things, that doesn't prove, you can't use that in this case. It's inadmissible.
okay.
You can't use that to show that he was negligent or any way or whatever. But the fact of the matter exists wholeheartedly that whatever's in the contract, he could have said, I promise I'll give you $1 million because whatever. But if it's not in the contract, it doesn't exist.
So there's no part of our contract that's bounding by verbal conversation?
No.
Okay.
Because it's the writing. Because I have to tell this to a lot of people, and so do a lot of judges.
Yep.
If you want it in writing, you have to make sure you get him to put it in writing.
Understand.
So if he had said then afterwards, and you had this conversation with him and you're like, Mr. Amrine, this is, this caused a lot of stuff and a lot of damage. And then he goes, dude, I'm going to cover it. I gotcha. That could be used, but he didn't say any of those things. That's why we're here.
Yeah.
So anything that transpired before the written contract doesn't matter or exist because it's whatever's in the document.
Okay.
Okay.
Mhm. So, in that context, we had, in Mr. Amrine's answer, he suggested that and stated that the rodent control was the responsibility of the renter.
The what?
In his,
The rodent control?
rodent control is the responsibility of the renter.
If you want this case done right now, I'll tell you right now, you're not proving your case. It is your responsibility. He is to make it weatherproof, not rodent proof. There is a complete difference in those things. All right.
I understand.
Now, if you would have said, hey, Mr. Amrine.
That's where I was.
If you would have said, Mr. Amrine, here, let me pull up your contract. If you would have said, Mr. Amrine, I'm looking at the contract right here, and you know what? It says right here, it says weatherproof. I don't know where it says weatherproof, but it says make it weatherproof. I want you to tell me that you're going to make it rodent proof too. If you would have said that to him in making this contract, you would have had to have put that in this contract for it to be binding. And if the rodents got in just like they did, and they damaged your stuff just like they did, he would have been responsible. That's not the case here. It's a pretty cut and dry case. It's a contract case. I've read this contract. I've heard the testimony. There is nothing here.
Other than his answer to the court, to my complaint that said that he suggested and said rodent control is the responsibility of the renter, me.
Right. Yep.
And I'm was going to go down the path of that was not communicated verbally. That's not in the contract. That's
for you to know, not for him to tell you. Here's the thing. You have to read. You have to edit.
Which I did.
You're right, but you didn't have him at it. You didn't have him put rodent proof. It says right here in paragraph 1, agreement includes supply and delivery by Applewood for 1 20-foot shipping container, SC 206 WWP. Here's the keywords here. Here's the absolute thing that makes this case, weather and watertight condition. Okay. If your property had any water damage at all, any water damage, any weather damage, any type of things that was from the atmosphere, the weather, boom, you win your case.
And
There's absolutely nothing about rodents.
And so if there was, holes in the roof,
Then that's on you. And it also says in here that you must insure, you, the renter, must insure your property, not him.
I understand. And my property was insured and
Bang, boom. And if they didn't cover it, that's between you and your insurance company. That's not for you to have him, because his contract says weather and watertight condition. You want me to get into the definitions? I sure can, but we're going down all of these things, and I completely understand your frustration. I completely understand your anger or being upset. Or you had nice property. There were nice couches and nice things there. But when you're looking at your agreement with a person, it's what is written in black and white on these 4.
I can understand the contract also, and I understand the framework of the contract and its value and its place in arbitrating where we are, right? Your Honor, I appreciate that, right? Where I'm really struggling is if weather tight has a meaning.
Here's the deal. I can tell you in case law, it says weatherproof. Legally, the term, quote, weatherproof does not imply, quote, pest proof. A structure can be perfectly sealed against rain and be weatherproof while still being
This is the turning point of the entire lawsuit. Up until now, the plaintiff has been trying to prove negligence, but the judge keeps bringing the case back to one thing: the contract. In contract law, judges usually enforce what's actually written, not what either side assumed or discussed verbally. Here, the agreement promised a container that was weatherproof and watertight, not rodent-proof. That single wording difference may decide the entire case. What do you think?
vulnerable to animals that chew through materials to create their own entry points or get in otherwise.
Got it. I understand.
Yeah.
Yeah.
And so that's the thing is that's not in there.
I don't disagree with you for sure. And the inference for me, and this is just Joe's opinion, and I know you're going to tell me that's interesting, Joe, it's just not relevant, right?
Yeah.
Which is, weatherproof, weathertight conversations that there's, that container has 6 sides to it. 5 of them are steel. One of them is a set of steel doors. And that the doors at that end are your entry point for a lot of things, including weather.
Agreed.
Right. And so they need to have a certain level of integrity in order to prevent water and anything else from coming in.
Not anything else. Not anything else. Weatherproof and watertight. I get what you want.
No, I'm telling you what I interpreted. I'm not saying that's what it is. You're educating me, right? And maybe Chuck knew this all along, and that's why we're here and why he's been resistant to entertain any sort of fair deal, as I would call it, between what happened and how it happened. I know that I didn't own the responsibility to make sure that the seals closed properly and that you couldn't see a gap when the doors were closed. That was Chuck's accountability, Chuck's responsibility. I believe he was negligent in that regard.
But he's pursuant to his contract, he's not.
Fair point. And that because it didn't say weather, it didn't say rodents, it didn't say insects, it didn't say all the possible points of intrusion that can cause damage. It was limited in that regard. And Your Honor, if that's where we're at, I can accept that. And I would tell Chuck, hey, it is what it is. I can accept that. And I candidly, I apologize to the court and Chuck. I've wasted a lot of time.
No, but here's the thing. And I know I've been a little, I just don't want, you have a right to come here and to argue. And this is a huge learning experience.
Mhm.
You're doing a great job. You are very organized and you're making arguments and those types of things. I don't know what you do for work, but the key difference here, and the thing is, it's like you're being prepared. How do I present a case? And you're good at that. You're really good at that. Except maybe identifying the exhibits. And you can a little bit help that.
Like this much.
Yeah, just a little bit. But the reason why there are lawyers, and I don't know if Mr. Amrine had a lawyer help him with this document or not help him with this document, but it's because they can pick out the issues in the case and what this is really about. And this is a plain and simple contract case, and you go off of the exact language. I have to strictly construe what is in black and white. Black and white. I can't go, well, you know what? It could be that it could mean this because some study said this or did this, or it could do this because something said this, or, maybe I'm thinking personally all of this. I can't do that because I am told by the Court of Appeals, by the Supreme Court, I have to strictly construe with the normal meaning, the specific meaning of the words. And I'm going to tell you, I'm pretty confident Mr. Amrine knew exactly what his words meant and why his contract is written the way it is and it's weather and watertight, weatherproof and watertight. It has nothing to do with rodents.
Yeah, and
or pests of any kind.
Yeah, and understand. And so I would say this, that there's no doubt from the documentation that I've provided that he did not deliver to me a container that was weather and waterproof.
And I love that argument. And you're trying really hard. And again, that's what lawyers do. And so that you're doing a good job, but wrong, it fails. Because had your